Good morning, everybody.
Good morning, Mr. Commissioner, members.
Yes. What have we got today, Mr. Mohapi?
Mr. Commissioner, we've got today Ms. Lindiwe Dlamini, who's going to be testifying on Steinhoff, and she's ready to take the prescribed oath.
Your full names, please, ma'am.
Lindiwe Sipiwe Dlamini.
Do you have any objections to taking the oath?
No, I don't.
You don't. Do you swear that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? Raise your right hand and say, "So help me God."
So help me God.
Thank you. You may be
you.
seated.
Thank you, Mr. Commissioner. Ms. Dlamini, you've prepared a statement with a number of annexures, the basis of which is the evidence you're going to be giving to the Commission. Is that correct?
That is correct.
Okay. If we can please start with your statement, then paragraph 1.1.
Sorry, Mr. Mohapi and Ms. Dlamini. There are a lot of legal and financial terms in this submission. So as you go along, just please explain the meanings of those terms, whether it's pledging, recessionary, whatever it is, you know.
Thank you, Mr. Commissioner. We have discussed that in our preparation, and we will take the Commission through.
All right. Okay, thanks.
Thank you, Commissioner. I will start with paragraph 1.1. I am an adult female admitted attorney of the High Court of South Africa. I joined the PIC on 1 July 2013 as a legal advisor in corporate services. From 6 September 2018, I became a senior legal advisor, unlisted legal investments, the position that I'm still holding today. Currently, I am the acting head of legal counsel and governance and compliance as of January 2019. I have been requested to provide a statement which details the role I played in my capacity as a legal advisor in the Steinhoff transaction, particularly the Blue Bug transaction. The facts contained herein are, save where otherwise stated, within my personal knowledge. The facts are to the best of my knowledge and belief both true and correct. Commissioner, through you, I will start with a background. Paragraph 2.1. There are two related transactions that the PIC entered into in relation to the Steinhoff matter, namely Project Sierra and Project Blue Bug. I believe that the full details of these transactions and their relationship have already been ventilated before the Commission during the testimony of my colleagues who have already appeared before the Commission.
Sorry to interrupt you, Ms. Dlamini. Perhaps as the advocate may be able to help us as well. One of the questions when your colleagues appeared was, before entering into the Lancaster 1-2 Sierra or Blue Buck, the full exposure of the PIC to the Steinhoff group in all its capacities, in whatever capacity it had, investments in Steinhoff. And we asked that the full exposure by the PIC that we be advised of that total amount at the outset. What was the number of shares, the percentage of shares held by the PIC in whatever capacity of Steinhoff, and the value before they entered into either of these transactions? Are we able to provide that information?
Commissioner, from a legal perspective, we are able to provide a little bit of assistance, but I would like to state from the onset that this analysis is one that is provided or done by the risk department within the PIC, because they have an overview of the entire portfolio as it relates to the various investee companies. And one of the things that they need to look at from a risk perspective is the direct and indirect exposure in relation to any particular individual or company. But Commissioner, if I point you to L1 of the annexures, on page 4, we did indicate, and this was pursuant to us, and by us I mean legal, being provided with the transaction team's scoping report. What we did deduce from that report was that the PIC had an exposure of about 10.5% shareholding in Steinhoff on the listed portfolio, which represented an investment value of about 33 billion at a share price of 72 Rand 70 as at 22 May 2017. And it further held 12% in ShopRite shares. And that's the extent of the exposure that we highlighted for purposes of our legal report. We also
Were you able to quantify the ShopRite value of those shares at the time?
Unfortunately, that assessment, as I've indicated, Commissioner, is one that is done by the risk department. Legal wouldn't be privy to that information.
Thank you, Commissioner. We will endeavor to obtain from risk the total exposure as requested by the Commission.
Continuing on paragraph 2.1, there are two related transactions that the PIC entered into in relation to the Steinhoff matter, namely Project Sierra and Project Bluebug. I believe that the full details of these transactions and their relationship have already been ventilated before the Commission during the testimony of my colleagues who have already appeared before the Commission. I would like to point out at the outset, I wish to point out that I was not involved in Project Sierra, being the initial transaction at the time it was entered into. Save to the limited extent set out in paragraph 4, I am not in a position to make any detailed statements relating thereto, as such information would not be in my personal knowledge. In order to ensure that the Commission understands the context within which I was involved within the Project Bluebug, I set out in broad terms the role that the legal department plays in relation to the consideration and conclusion of transactions at the PIC, and this is really by way of background. If I may now deal with paragraph 3, the role of the legal department in transactions. Normally, a transaction is initiated by the investment team, which is responsible for structuring same. The investment team commences the process of gathering information from the investee company in order to, inter alia, develop a scoping report, which is then submitted to the Portfolio Management Committee 1 for approval to proceed to due diligence stage. Once the investment team is authorized to proceed to due diligence, the investment team would request a resource from the legal department in order to conduct a legal due diligence investigation.
Just to be clear, when referring to a resource there, we're talking about a person,
Yes, this is somebody who is selected by the executive head of legal to assist the transaction team from the initial stages of the transaction to completion. In our case, the executive head of legal would then allocate such resource on the transaction. The legal department consists of the executive head of legal, a senior manager, a senior legal advisor, a legal officer, and legal interns. The senior manager, senior legal advisor, and the legal advisor report directly to the executive head of legal. A resource that would be allocated to work on
Just to
it.
check. Okay, yeah, no, go on, please.
Just in terms of its executive head legal, is there a distinction drawn between executive head legal and the work done which relates to contracts, relates to assessment of risk as a legal entity, and in terms of the work of the PIC, as distinct from a legal counsel who would work with the executive, the board, as to the issues that and the laws that apply to their work and how that is affected? Does the executive head legal play a role in that regard, regarding the executive? Are they in attendance at executive meetings or board meetings, playing a role of a legal counsel rather than a legal, if you like, executive for the functioning of the PIC?
Thank you, Commissioner. So, Commissioner, you are quite correct. The role of the executive head of legal is, it's a dual function, if I may. Maybe if I can zoom in on the legal department specifically. The executive head of legal would need to obviously provide the legal team with a structural leadership, in the sense that any transactions that are coming through to legal would obviously need to be allocated by the executive head of legal. The executive head of legal would also need to play an oversight role to the extent that there's an impasse on transactions or there are contentious issues that need to be dealt with. The executive head of legal would effectively have to step in and assist the transaction team in dealing with some of those issues, given you know, the seniority and the expertise that that person will possess. From a globular perspective and in relation to the PIC, the executive head of legal, as you've rightly put it, will also play a management function and will sit in executive meetings, will play an advisory role in relation to the board and management as a whole, will also interface with the regulators and any other stakeholders insofar as legal issues are concerned pertaining to the PIC. So it's quite a convoluted role. It's a multifaceted role which the executive head of legal plays, not only within the scope of the business unit, but also in terms of legal as a whole.
So would that person, as a general rule, sit in on board meetings?
Perhaps if I can ask clarity from the Commissioner, board meetings in the sense of investee companies?
No, the PIC board.
So, as part of management, the executive head of legal will sit at the PIC board and will provide the board with legal advisory services to the extent required. So it is a normal function for the executive head of legal to sit at the board to provide legal services to the board.
Can I just stay with that a minute? Do they provide at request, or do they have, if you like, a kind of watching brief? The board is looking, and we've seen quite a lot of discussion about what the board does or doesn't do, and what is, just given all the issues that have arisen. Would legal counsel have been sitting in those meetings and saying to the board, in terms of the legislation, in terms of governance, in terms of this, not whether you're asked, right, but whether you say, you want to do the following, what is your role? As distinct from a person who has legal experience on the board, because we've seen that particular role, the question of the head legal playing that role of advising the board about its obligations, if you like, its parameters, the legal frame, and so on. Does it play that role? Because that has not come through for me. We've seen other people playing that role on the board, but I haven't heard any reference to legal counsel's advice to the board in all of these discussions.
Thank you, Commissioner. So, Commissioner, you are actually quite correct. So it's a two-pronged approach. There will be submissions that are ordinarily made to the board that are emanating from the legal department, which we will submit to the board and deal with those submissions, and that would be in the ordinary course of business. So, for instance, we will report on pertinent matters pertaining to litigation. We will report on investments that need to be brought to the attention of the board and the like. But we will, issues that are emanating from discussions of the board on an ad hoc basis, legal does sit in on those board meetings to provide legal advisory on those issues that are emanating from the board. It is important to make a distinction that, as the head of legal, you owe a fiduciary duty to the company. You therefore need to advise the business on the legislative parameters that they can play within and compliance issues. So that function is being played by the legal division or the head of legal. And we do advise the board on issues that are emanating from the discussions that are happening at a board level.
So, sorry I don't want to belabor the point, but given I'm not talking about Lancaster now, but if you're talking about the kinds of discussions that we've been having about, the processes regarding investigations, the emails, the anonymous emails, and so on, one's heard of what's been part of testimony is the role of different members. But did the head of legal play any role in those discussions? And if so, what advice did they give in terms of process to look at these kinds of activities? I know it's not related to the subject matter that you are here now, but given that you are here, I think that for me it's been something that I haven't been able to to fully understand where legal has played a role in all of this convoluted activity of the board. Resigning with the legal counsel there and discuss part of the advice when the board decided to write a letter to resign. Those kinds of areas was legal counsel's opinion sought and given.
Thank you, Commissioner. Commissioner, perhaps it's also quite pertinent for us to highlight that there are some discussions that the board will have that are in-camera sessions, and that is where management would effectively be requested to recuse itself. And I think this particular issue pertaining to resignation was one such instance where management was requested to recuse itself. So in those circumstances, no legal advisory would be provided because I was not sitting in that board meeting. I think, Commissioner, issues that predate me, I unfortunately cannot speak on issues that are predating me in this role. But what I can say, Commissioner, and I can speak personally for myself, is I have been vigorously advising the board on a regular basis. The board has subsequently established a task team where I can provide regular reportings on matters pertaining to issues like Steinhoff, AO, and VPS, where robust action is being taken by legal. You would have seen in the media that there's been quite a lot of activity on the AO in relation to CIPC. So those matters, I would on a regular basis advise the board and the board task team on those instances. Any matter pertaining to legal and pertaining to compliance, which warrants us bringing it to the attention of the board, is done so immediately, and we do engage the board on how we need to proceed or what the way forward should be, and we are given that level of direction. But to the extent that that decision needs to be taken by management, there's also the executive committee that regularly sits where we deliberate these issues and decisions are effectively taken. So there is a robust engagement. Legal is playing a very pertinent role in advising not only the board but management in an effort to dispel its fiduciary duties to the company.
Let me ask a simpler question, hopefully. If the board were to have a legal issue that it has to deal with, whatever it is, and they say we need to be advised on what the law says in this regard, and so on, does that issue get referred to your legal department or do they outsource?
So, Commissioner, through you, that matter will definitely be referred to me as the head of legal, and to the extent that I can deal with that particular matter, if it falls within my purview and my knowledge, I will deal with it and advise the board accordingly. In instances where I do require time to obviously do the necessary research and provide them with proper guidance, I will do that, and I will request to revert to them at a later stage. To the extent that it's a technical matter that really requires us to bring on board an external resource to assist us with the technicalities surrounding that particular issue, we will do so and report it to the board, and the board will accordingly take the decision based on the recommendations that we've provided them.
Are you thus the first port of call if there is a legal issue within the PIC?
Yes, Commissioner.
Whatever the matter it is.
Ordinarily, that's how it should be.
Is it? You say that's how it should be.
Commissioner, in the absence of being involved in some of the board deliberations, I wouldn't know if there are any other legal issues that are emanating from, for example, in-camera sessions. But to the extent that I am in those sessions and legal issues are discussed, I will definitely deal with those matters.
Okay, thank you. Let's proceed from 3.5.
Thank you. A resource that would be allocated to work on a transaction would be selected from the positions of senior manager, senior legal advisor, and the legal advisor. The legal due diligence investigation may be undertaken in-house by the resource allocated on the project, or it can be outsourced to an external service provider on the PIC panel of attorneys.
Okay, so just to explain that point, when would the assistance of external legal service providers be enlisted in respect of legal due diligences?
One of the assessments that we need to make from a legal perspective is the complexity surrounding that particular transaction. So to the extent that it's a highly technical transaction, we would ordinarily procure the services of people who are specialists in the field. I'll give an example. One of the issues that we don't profess to be experts on is tax. So to the extent that a matter has serious tax implications, which on a first glance we as the internal team have highlighted, we will recommend to the committee that, look, we need to get a tax opinion, or we need to get advisory around this particular tax issue to understand what the extent of the liability will be for our underlying clients. And I think the other issue that we also take into account is capacity. To the extent that we don't have capacity to deal with a matter that is quite voluminous and quite large, we will also procure the assistance of external advisors.
So just in relation to that latter point of capacity, can you give to the Commission sort of a sense of how many personnel there are in the legal department?
So the legal department, relative to the other departments within the PIC, is quite small. I think if I can break it down, I don't have the overall number, but if I can break it down, they are in the listed division. I have two people sitting in the listed division, and I'm not including interns. In the unlisted space, we effectively have 2 people sitting in unlisted. In corporate services, we have 3 senior people sitting in corporate services. And that's basically the composition of legal. We have quite a few legal interns that we are training, but the training process is that after they've spent a year with us, they go out and they spend a year at legal firms so that they meet the requirements of the law society. So there is a bit of a gap in terms of, I did forget the properties division. There are 2 people sitting within the properties division as well.
Do you have many vacancies in your establishment?
Commissioner, through you, we do have vacancies, and I've recently advertised a few positions. We're sitting for those interviews in the next coming weeks. So we are trying to deal with the issues of capacity.
Question, just in terms of capacity, do you guys benchmark with the biggest asset managers? I mean, you manage 2 trillion rands. Do you check how the other asset managers have in terms of legal departments? Sort of Investec Asset Management manages about 2 trillion rands. Actually, it's the same size as a PIC. So do you guys sort of have a look and say what kind of a legal department would they have?
Commissioner, through you, this is a very contentious matter that we keep raising with the business, particularly HR. Every time we raise this question, we are told that the structure has been benchmarked. Unfortunately, I was not involved in the structural discussions because those happened in 2015 when the organization was restructured. At the time, it was Ines Nasani who participated in those discussions. But if you ask my personal view, Commissioner, I don't think it's aligned with the asset managers in the market.
Yes, because you probably sometimes end up spending more money with the external advisors than spending it locally, internally, in the sense that the basic things you can do, but there's not enough staff.
I think, Commissioner, you're absolutely 100% correct. And one of the things that I did raise earlier on is the issue of capacity. The PIC in the normal course of business is generating transactions at the size of the other asset management and managers in this space. But unfortunately, from a capacity point of view, we are finding ourselves lagging seriously in that we are entrusting, all these transactions to effectively two personnel within the respective spaces, which for me is a serious risk, and we have highlighted this risk. And I do believe, in my personal opinion, that legal needs to be sufficiently capacitated. Given the fact that we are not only looking at transactions, we're also looking at PIC corporate, which effectively needs to look at, the level of compliance from a legal perspective. We're also looking at labor-related matters and compliance in respect of the labor regulations and the laws. So I think it's unfortunate that we find ourselves where we are. I'm hoping, pursuant to this, we'll have more robust discussions about what the structure effectively needs to look like.
Otherwise, you don't have an idea as yet how many resources there should be.
In the absence of doing the requisite benchmarking, Commissioner, I don't have the numbers. Perhaps this is something that can be provided by our HR, the head of HR at the PIC.
Just to check something, given that there are so many vacancies within the PIC, is this a question of money, or are you getting enough fees from GEPF and the other clients, or it's just a question of you are not getting the people, you are advertising the positions, but you are not getting the people? What is it? What's the problem here?
Commissioner, through you, I think my response can only be limited to the legal space. But I think it's a general discussion that perhaps the Commissioner needs to be given a proper response, because I really think there's a serious problem in, I think post-2015, there have been mass resignations at the PIC. And the time within which we find ourselves replacing those vacancies, I think it's something that's a little bit concerning. But if I come back to the legal space, Commissioner, we have sent adverts in an effort to fill vacancies, and people are responding. So I don't think it's a question of whether or not there are people who are interested in coming to the PIC, because I think the interest is there. From a budgeting perspective, Commissioner, I think the budget is there. I think it's just us having the will, the will to fill these vacancies and do the necessary work that is required to fully capacitate the PIC, because you're quite right, it does affect the operations in that the PIC cannot function optimally if it's not adequately capacitated.
So it's just a question of just doing it, because the money is there, the people are there, you must just do it.
I agree.
Yeah. Okay. All right.
Thank you. Moving on to...
Sorry. I know we're stuck here a little bit on other issues, but just a quick word about the panel of attorneys. How often, how broadly, what is the process to appoint the panel? Do you appoint firms? Do you appoint individuals? Is it rotational? What is the time period? Just a sense of the panel, the PIC's ability to draw on the legal profession externally and as part of adding to the skills that are required.
Thank you, Commissioner. So the legal panel is revised on a 3-year basis. We run a tender process where we send out an RFP. We send out an RFP to all the firms in the country. We run a robust RFP process, and what I can say about the panel is that we look at different firms and we categorize them based on their skill set. So we look at everything from properties to litigation to corporate and commercial, finance and banking and the like. So once that work has been done in conjunction with our procurement team, we then select the panels that obviously meet the administrative requirements and that obviously score high in terms of the procurement scoring. We then bed down this legal panel, and we categorize the firms based on what we think, from their skill set, what we think they can provide to the PIC with the necessary skills. So it's quite a voluminous panel. It's quite a big panel. It's quite a diverse panel. What we try to do as well within the PIC when we procure the services of these firms is to ensure that there's a rotation system, and that process is managed by our procurement team. But obviously, as the head of legal, you get a sense of the firms that keep coming back over and over again, so there needs to be a level of pushback on your side as well. Because I think people start building relations with individual lawyers, and you start to see a trend of, preference being given to certain lawyers. So you have to also, play that role to say there has to be a rotation system, because the skill sets are unquestionable, the credibilities of the firm is unquestionable. The fact that they're on our panel means they are credible firms, we've assessed them, and they can do the work. So we do try by all means to ensure that there's a fair rotation process. There's also a twinning exercise that we do encourage the firms to embark on. Sometimes it can be initiated by us, sometimes it's initiated by the firms themselves, where you would see a big firm partnering with a medium-sized firm or a smaller firm to ensure that there's adequate skills transfer. What we do try to do in twinning arrangements is to also make sure that the work is equitably distributed, and you don't see a situation where the small firm is doing menial work and the larger firm is doing, the bulk of the work. So that process is also managed by myself.
Just another question, sorry to stay on this matter, yeah. In terms of, I just want to check, in terms of the big legal firms, ENS and all that, I mean, they are multidisciplinary, they got tax, they got everything. How do black firms actually manage to do the work? What kind of work do black firms do, given that they might have limited disciplines within their firms?
Commissioner, I'd like to take this opportunity to just demonstrate the work that some of these black firms are doing. I'll give you an example. There's a firm called Gwina Attorneys that's doing exceptional work for the PIC. They've been assisting us with, very complicated matters. And I think, Commissioner, what's important is the PIC having the will to have faith in the firms that are on our panel, especially the black individuals behind the firms. We do try and make sure that on complicated transactions, for instance, your derivative type structures, your SIPS portfolio, your SIPS type structures, we obviously bring in. And what you will find, Commissioner, before I lose the point, what you will find is that behind these smaller black firms, it's ex-employees of the bigger firms. So, we cannot question the credibility of those people that are running the firms. They are doing credible work. And I think we do have those ongoing discussions with them to say, look, perhaps you need to beef up on your compliance function. You need to beef up on your tax function. And I think it's a matter of, is the PIC giving us enough work for us to bring in a resource to deal with these matters specifically? Because we can't have an expectation that they're bringing this resource, but we're not giving them the work to be able to, sustain this structure that we are asking them to implement within their organization. So there are very credible small firms. I can name all of them, but I don't think we have the time. But we are really doing good work with the smaller firms.
And Gwina, what does they do? I mean, what is their specialty?
It's a multidisciplined law firm. They do corporate and commercial, they do finance, they do litigation, there's a little bit of tax. So while the skill sets are there within the firms, obviously they can't diversify if they are not sustained by the work that's coming through. So I think for me, that's the biggest issue that we're trying to grapple with, to capacitate them enough so that when they bring in the resources we're requesting, we're able to sustain them.
I think we must refrain from naming the firms lest we are accused of advertising on their behalf.
Agreed, Commissioner.
Okay, we can proceed to 3.7.
Upon completion of the legal due diligence investigation, a legal due diligence report gets prepared by the resource. The report is submitted to the executive head of legal for review and sign off. The resource will then submit the report to the company secretary for onward submission to the Portfolio Management Committee 2. The report would include recommendations relating to inter alia, what conditions precedents, conditions subsequent, and standard warranties and representations to be included in the definitive legal agreements. These would generally be informed by legal and commercial risks identified in the legal due diligence process.
Okay, can we just spend some time explaining then to the Commission these terms, conditions precedent, conditions subsequent, standard warranties, representations?
Thank you. So the legal due diligence process involves identifying the legal risks on any particular transaction. One of the things that we need to then bring to the legal report is potential risk mitigants that we think legally can be bedded down in the definitive transactions to mitigate that particular risk that we've highlighted. Condition precedents are typically things that need to be fulfilled before the transaction is finalized by the team. So those conditions would need to be satisfied before the PIC. In the event that there's a disbursement required, the PIC would need to satisfy itself that those conditions have been met prior to the disbursement flowing. So typically this would be the requisite resolutions from a governance perspective. The requisite resolutions have been signed by the company authorizing the transaction, but it really just depends on the risks that you've highlighted. Conditions subsequent are obviously conditions that can come after the disbursement process has happened. And typically this would involve things like the registration of bonds, because nobody has control over the time frame within which these processes can be finalized. For instance, the registration of a mortgage bond can be a condition subsequent as long as the bond papers have been lodged, and it now becomes an automatic process of finalizing the bond registration. So typically you would see that coming through as a condition subsequent. Warranties are typically where we require our counterparties to warrant certain state of affairs. For instance, that the entity is a valid entity with a valid legal standing. So those are the things that we would want our counterparties to give us assurance on, and these are typically sometimes things that we can't verify for ourselves. I think similarly with representations, it's similar to warranties, where certain representations are made to the PIC in the absence of us confirming such representations. So those are typically the security type structures that we try to include in legal agreements to mitigate risks that we've identified in the transaction.
Yeah, we can move on to 3.9.
What happens, just for interest's sake, what happens if there is a condition afterwards, after you have made the disbursement and there is no fulfillment of that condition?
So typically, if conditions aren't met, especially if it's conditions subsequent, Commissioner, the PIC will have a legal recourse or remedial action that it can take against the counterparty for not complying with those conditions. In such instances, it would ordinarily now be construed as a default or a breach of the legal agreement. And typically in those circumstances, we would then issue a default letter to say that you haven't complied with the condition. And given the security or the rights that we've negotiated in the legal agreements, we would obviously follow that process in then perfecting our security or following our rights in terms of the legal agreements.
So ordinarily there will be a security?
Ordinarily there will be. If PMC2 has the final authority to approve a transaction in terms of the delegation of authority, the transaction proceeds to the implementation stage. If the transaction value exceeds PMC2's delegation of authority, the submission would be referred to either the investment committee or the fund investment panel, depending on the nature of the transaction. Once a transaction has been approved by the relevant committee, the legal department assumes a role of ensuring that the transaction terms as approved by such committee are reflected in the transaction agreement. Prior to the actual execution of the transaction agreements, the relevant department involved in the transaction are required to sign a signature memorandum, which is prepared by the legal department. The other department provide input into the signature memo and the transaction agreements in respect of their respective areas in relation to the transaction.
Okay, so when talking about execution there, we're talking about signing the agreement.
Yes.
And when talking about signature memo, it's one of your annexures, it's L4, that is an example of a signature memo.
Yes. Once the transaction agreements are signed, the legal department would assist in the process for the fulfillment of CPs and, where applicable, disbursement of the funds. Paragraph 4. Summary of the previous security arrangement under Project Sierra. On or about 8 September 2016, the PIC entered into a term loan facility agreement with Lancaster. In accordance with the terms of the PIC loan agreement, the PIC advanced a 5-year term loan facility to L101 in the amount of 9.35 billion for purposes of, among others, acquiring a 2.75% equity interest in Steinhoff International Holdings NV. I'll refer to it as Steinhoff from here on. And that was Project Sierra. L101 entered into a 5-year average term collar with Citibank Limited, pursuant to which L101 ceded and pledged as primary ranking security its rights, title and interest in, and to 75% of the Steinhoff shares as security for its obligations under the collar to Citi. The balance of the 25% of the Steinhoff shares was ceded and pledged to the PIC as security for L101's obligation under the PIC loan. As part of the 5-year average term loan.
There are many terms there, many legal terms, many financial terms. Just explain them. And the other question is that in terms of the cover ratio, what did the PIC get in terms of the loan that they gave to L101?
Commissioner, through you, in relation to the cover ratio, I can have a look at the legal agreements if you will indulge me, but I think, I don't know if I can express a view regarding the commercial terms, but I can attempt to look at the legal agreements and give you an answer.
Yes, but it seems that the collar does cover some of the security too, in some ways, given that.
Yes, the collar does.
Price.
Yes, the collar does. Without professing to be a financial expert, but the collar did cover the downside protection, and I think the arrangement there was that it was on a reversionary basis because 75% of that was then ceded to Citi, and the balance was then ceded to PIC. Perhaps if I can look at the terms, and perhaps Advocate can help me. Which terms do I need to explain?
Start off with your reversionary that you've
Just
just
the terms,
mentioned.
yeah. Just the terms. Stuff like LO1 ceded and pledged the shares, so, when you give a loan, you give the shares to the lender,
So let's, if I can be of assistance, explain what is meant there in paragraph 4.2. Yes, that L101 ceded and pledged its rights.
So, Commissioner, for the security for the loan that the PIC provided, L101, PIC, I think at the time, because this was Project Sierra, would have indicated to L101 that as security for the loan that I'm giving you, I will effectively take over the shares. In a default scenario, depending on what the value of the shares, the PIC has the ability to realize some value under the shares. Obviously, that now becomes a valuation issue, but that now secures the PIC's position insofar as if there's a default and L101 is unable to pay under the loan obligations, it will have the right to effectively step into the shoes of L101 and take over the L101 shares as security for the loan obligation. And perhaps if I can then deal with the concept of reversionary. So typically what happens if one takes security on a reversionary basis, it means that there's somebody obviously front ranking you. In this particular instance, it would have been Citi, because Citi would have, in a default scenario, Citi would have had the first bite at the cherry, so to speak, and the PIC would have been secondary or would have been in a position to realize any residual value after Citi had realized whatever security was accruing to Citi. So being in a reversionary position effectively means that you are next in line to take over whatever the residual value of the security is.
And am I right saying that the 100% of the shares that PIC got from Lancaster, they had to cede or give away 75% of the shares to Citi for the caller and keep only 25% of the shares?
You're right, Commissioner.
As security, is that
You're
correct?
100%, and that was in an effort to protect the downside.
Yeah. Okay.
And how do you prove that the shares have been ceded to a particular party? Is there a certificate issued, or is it just the agreement that you rely on?
So, Commissioner, through you, typically what we will do is we will enter into a pledge and cession agreement which will stipulate the rights that you as a security holder effectively have in relation to the security at hand. Once you perfect that security, obviously the necessary certificates will obviously need to be handed over to you to confirm your ownership of those shares. So that typically happens on a default scenario where we are perfecting our rights. But the pledge and cession agreement is critical to demonstrate the right that the PIC effectively has over that security.
And in this instance, we've got a pledge and cession agreement as Annexure L12C in this particular transaction.
Yes, I think I deal with it further on in the statement.
No.
Yes, we can proceed.
Okay, we can proceed. Paragraph 4.3.
As part of the 5-year average term collar, L101 had a put option against Citi in respect of its 75% security of the Steinhoff shares. As security for L101's obligations under the PIC loan agreement, the following security was provided in favor of the PIC. A cession of any proceeds received under the put options referred to in 4.3 from Citi, a primary ranking cession over 25% of Steinhoff shares not pledged to Citi, a cession of dividends on the shares in respect of which Citi is not required to borrow for its ongoing risk management for the collar, the non-delta shares, and a reversionary cession over 75% of Steinhoff shares pledged to Citi. Paragraph 5, summary of the security arrangements under Project
Just to be
Blueback.
clear, so in 4.4.1, basically you are saying the proceeds of the put option that happened gets given to the PIC. Yeah.
Correct.
Yeah. And then 4.43, you are saying any dividends that are given out by Steinhoff, the ones that are not related to Citi will go to the PIC.
Correct.
So there is some cash of sorts coming back to the PIC.
Correct, Commissioner.
Okay, all right.
I think let's go back to put option. I think somebody explained it to me, but it's gone out of my mind again. What is a put option?
Yeah. So, yeah. Okay.
So, Commissioner, a put option is basically an agreement where you have the ability to put the shares to the counterparty. So you have a right or an option to put those shares to your counterparty in the put option arrangement. I'm not sure if it was explained in that fashion, but that's simplistically how I can explain it.
But the rationale of having one is to protect you, to give you downside protection.
Correct.
If one understands it, it's the ability for somebody who has bought shares to protect themselves, and they buy a put option from somebody, and that somebody pays them something for that put option. Is that correct?
Correct.
Yes, yes. And they are protected also
Correct.
on the downside at a particular share price.
Yes.
Okay. I don't know whether it's clear, but that's the best that can be done.
I think it's, for me, it makes sense.
I think proceed.
Let's proceed to paragraph 5.
5.1. Following conclusion and implementation of Project Sierra, L101 and Lancaster Group Proprietary Limited approached the PIC to request the PIC support for Lancaster's proposed equity participation in a newly established and separately listed entity, Steinhoff Africa Retail, now renamed Pepco Holdings Limited, that would ultimately house Steinhoff's Africa assets and 22.73% equity interest in ShopRite, referred to as Project Blueback. In accordance with the structural mechanics of Project Blueback, Lancaster Group would obtain third-party funding from Citi in an amount of circa 6.57 billion rands. We refer to it as the Citi loan, to, amongst others, acquire a 5.9 equity interest in Star through L101. Furthermore, Lancaster Group established a new BESPV, the special purpose vehicle, which we refer to in the statement as L102, which would in turn obtain funding from Steinhoff-related entities for the purposes of acquiring an additional 5.9% equity interest in Star, 102 Star shares. The total purchase consideration for the two acquisitions of equity in Star was circa 6.2 billion rand each. In order to facilitate Project Blueback, the PIC agreed to effectively subordinate its security interest under Project Sierra as set out in paragraph 4 above by substituting the above-mentioned security package for a new security package under Project Blueback as follows.
Sorry, what is, I think you said, how did you pronounce that word, C-I-R-C-A?
Sierra.
Circa. What is-
Circa, it's approximately.
Approximately.
Yes. As security for L101's obligation under the Citi loan, the PIC would relinquish its rights over the primary ranking session over 25% of Steinhoff shares not pledged to Citi, such that Citi would have primary ranking security over 100% of the Steinhoff shares. The PIC...
Okay, sorry, so meaning even that 25% is now gone,
This is Blueback, yes.
Right,
And this, and I think it's important to highlight, this was on the backdrop of Citi bringing in its funding to allow L101 to acquire the Star shares.
for the 6.5 billion rand loan,
Yeah,
okay, which is from Citi.
yes.
Okay.
The PIC would acquire reversionary security over 100% of Steinhoff shares pledged to Citi. So this is where the reversionary arrangement comes in. Citi would effectively take 100% primary, and we would take a reversionary position on Steinhoff. Citi would be entitled to downside protection from the proceeds of the collar option on a primary basis, and the PIC would instead obtain downside protection on a reversionary basis. The PIC would acquire primary ranking session and pledge over 100% of the L101 Star shares. L102 would provide a guarantee in favor of the PIC for the due and punctual performance of L101's obligations under the PIC loan agreement, and the PIC would acquire reversionary cession and pledge over 100% of the L102 Star shares, in respect of which Steinhoff, as the primary lender to L101, would have a primary ranking cession and pledge. This cession and pledge instruments were to be provided by L102 as security for its obligations under the guarantee agreement referred to in paragraph 5.3.5. The re-ranking of the security package was a condition to City agreeing to make the City loan available to L101 for the purposes of acquiring equity interest in Star.
Just to check something, 5.3.6 didn't happen because Steinhoff didn't supply that loan.
Commissioner, and I deal with it later on in my statement, the actual participation on Steinhoff on L102 didn't happen, but from a legal perspective, what we did do was to make sure that the necessary agreement to make sure that the PIC's rights were preserved were bedded down. So you will see that and it's included in the annexures, the guarantee, the limited guarantee agreement was entered into and was signed between PIC and Lancaster, and the pledge over the shares was also signed between PIC and Lancaster. And this was in anticipation of Steinhoff bringing in its funding to L102 to then acquire the 5.9% shares of Star. But you're quite correct that the funding never came through. The re-ranking of the security package was a condition to City agreeing to make the City loan available to L101 for the purposes of acquiring an equity interest in Star. The legal department's understanding of the commercial rationale underpinning PIC's participation in Project Bluebug was that the PIC would be secured to a value of approximately 12.4 billion, taking into account the 102 Star shares pledge, with the additional requirement that the collar option executed in relation to the PIC loan agreement would remain in place. No additional capital was injected by the PIC in relation to Project Bluebug. We'll move on to paragraph 6, which depicts my role in Project Bluebug. I am the legal resource that was assigned by the then executive head legal, Mr. Ernest Nasani, to work on Project Bluebug following the approval of the project by PMC1. In light of the fact that Project Bluebug was in essence the restructuring of the security arrangements under, and therefore an amendment to the PIC loan agreement, it was not necessary to undertake a detailed due diligence investigation nor to outsource any analysis thereof to external legal consultants. On 26 June 2017, and following the analysis of the Project Bluebug, I then compiled a memorandum containing our findings and recommendation in relation to the proposed restructuring of the security arrangements under Project Sierra, addressed to PMC2. This memorandum is attached as Annexure L1. It is
L1.
Yes, L1. It is.
Sorry, if we can just have have a look at your recommendations or conclusion of that particular memo. I note that it's paragraph 16 and 17. If you can just read that into the record.
The recommendation is as follows. Legal risk in respect of the transaction is moderate. From a security perspective, due to the fact that the PIC is not a shareholder in L102, we are of the view that this exposes the PIC in that the security proposed in the L102 structure is insufficient to cover the PIC's full exposure on the L101 loan. To mitigate this risk, the PIC intends to negotiate a shareholding and upside participation in L102 for the risk taken as a result of subordinating the PIC security in L101. The PIC will now have a primary cession and pledge over the L102 LISCO shares and a reversionary cession and pledge over 100% of L101 shares in Steinhoff. Furthermore, the PIC must be provided with a primary cession and pledge over the L101 LISCO shares once City has perfected its security, realizing the value of its loan under the L101 Steinhoff shares. In the above circumstances, legal recommends that the transaction approval be considered subject to the above-mentioned mitigation measures and proposed security structure.
All right, thank you. Can move on to paragraph 6.4.
Just to check something, were this taken, were this approved and implemented?
Yes, Commissioner, these
Okay.
were adopted in the IC resolution, which is also annexed to the submission as Annex to L2.
All right, okay, thank you.
6.4. It is to be observed from the legal DD memo that the legal department identified legal risks and made proposals on how best to mitigate such risks. Further, the legal department made recommendations relating to security arrangements around the L101 star shares and the L102 star shares. Project Blueback was approved by the Investment Committee on 24 July 2017. A copy of this resolution is attached as Annex to L2. It is to be observed that some of the terms that were approved by IC included primary cession and pledge over 100% of the L101 star shares and a reversionary cession and pledge over 100% over the L102 star shares, as per the legal DD memo. Following approval of Project Blueback by the IC, the legal department outsourced the drafting and negotiation of the relevant agreements to two law firms, namely Cliff Decker Hofmeyer and Gwina Attorneys. The agreements that needed to be drafted and concluded included, without limitation, the release and implementation agreement, an addendum to the PIC loan agreement, the primary pledge and cession in respect of the 101 star shares, the L102 guarantee agreement and reversionary pledge and cession in respect of the L102 shares. All these agreements have been annexed to the submission. The process of negotiating and conclusion of inter alia the release agreement, the loan agreement, and the 101 star shares pledge commenced from July 2017 following the IC approval. A signature memo was circulated on 23 August 2017 for signing. I attach here two copies of the release agreement, the loan addendum, and the 101 star shares pledge marked as Annex to L3A, 3B, and 3C respectively. I deal with the balance of the other key agreements in paragraph 6.24 to 6.26 below.
So, Mr. Commissioner, I note that it's 11 o'clock, and I wonder whether the commissioners wish to take a tea adjournment.
The suggestion is that we carry on.
It is to be observed that in terms of clause 4.1.4 of the release agreement, the CPs to Project Blueback included the conclusion of the following agreements, which is defined as the transaction documents in compliance with the IC approval. In respect of L101 and L102 agreements, the conclusion of the loan addendum between PIC and L101, the conclusion of the 101 star shares pledge, the conclusion of the reversionary cession and pledge in respect of 100% of the Steinhoff shares ceded to City, the conclusion of the guarantee agreement, and the conclusion of the 102 star shares pledge. In respect of Steinhoff agreements, the Steinhoff funding instruments, the conclusion of a loan agreement between Steinhoff and L102 in the amount of 6.2 billion, and the conclusion of the primary cession and pledge agreement between Steinhoff and L102 in respect of the 102 star shares as well as L102's shares in Tybalt Square Financial Services. In respect of Citibank agreements, the conclusion of a loan agreement between Steinhoff and L101 in the amount of 6.2 billion, and the conclusion of a primary cession and pledge in respect of 25% of the Steinhoff shares released by the PIC. Further, included as a CP to the release agreement, the PIC had to be provided with evidence to its satisfaction that the listing of the star shares was to take place on 30 September 2017. In terms of the release agreement read with clause 3.1 of the loan addendum, in essence, the above CPs had to be fulfilled by 25 August 2017. In terms of clause 4.5 of the release agreement, the date for the fulfillment of the CPs may be extended by agreement in writing between the parties. On 23 August 2017, I compiled a signature memo addressed to the then CEO, Dr. Daniel Machila, inter alia, identifying some of the key agreements that needed to be signed for Project Blue Bug. The memo is attached as Annexure L4. On 25 August 2017, being the date on which the CPs had to be fulfilled, we received an email from ENS Africa, who were the attorneys to Lancaster L101 and L102, to the effect that their clients were encountering challenges in fulfilling certain CPs and asking the PIC to waive the fulfillment of such conditions, the ENS CP's email, which is attached as Annexure L5.
Just as a point of emphasis, if we can go to that annexure. And if you can just deal with this email.
Thank you. We received an email from the ENS counsel, Deborah Carmichael, which basically stated that there was a requirement that the lender satisfy itself that the listing will occur. How will it, I'm not sure, I don't think it reads correct. But the gist of it is that how will we satisfy ourselves that the CP is met? Should we provide the draft pre-listing statement? Perhaps, Steve, you can chat to your partner at CDH, Willem Jacobs, who is running with that transaction for Steinhoff. On the Steinhoff funding document, CP, we are not going to be in a position to satisfy the second leg of that CP, the Tybalt subscription. Although we do have an unsigned execution version of the Tybalt subscription agreement to hand, Tybalt has been unable, given the timing pressures of this transaction, to give effect to the administrative requirements, in brackets, resolutions, etc., to effect the necessary increase in the authorized share capital in order to issue the shares. Further, I understand that the relevant Tybalt signatories are not there as of today. What we do have, however, is the unconditional loan agreement with an obligation on the relevant Steinhoff entity to fund L102. Although PIC won't be able to take the reversionary security it would have over the Tybalt shares today, it does in its capacity as shareholder of L101 have an indirect claim as shareholder to the 4 billion cash currently available in L102. In the circumstances, we would ask the PIC to take a commercial view on this CP and partially waive fulfillment of it, i.e. waiver of only the second leg of the transaction. We would be grateful for a time period waiver where we could start work with Tybalt on Monday to start working on the documents necessary to increase the share capital of Steinhoff and to authorize the issue of the Lancaster 102.
So just in conclusion, that waiver, what happened? What happened in relation to the request to waive the CP?
Commissioner, through you, the matter was brought before me. I then indicated my discomfort with the waiver to the commercial team. I indicated that to the extent that this condition was going to be waived, we would obviously need to approach the committee to approve that. It was then suggested to me that can we defer the CP to a later date? If you look at Annexure L6, there is an email email correspondence between myself and Mervyn where I said I'm happy to extend, provided that by the time we release, we obtain the confirmation. I think it will be a timing issue more than anything. I've requested Stephen to find out how long they need, but ideally we should be provided assurance prior to our release. And this instruction was then communicated to ENS, if you look at Annexure L7, where there's an email from Mashudu Tidiela to Deborah Carmichael, which indicates that, pursuant to discussions that were held yesterday, please note that our instructions are to hold the release letter, instructing Standard Bank to remove the flag over the pledged shares in escrow until further all CPs under the release and implementation agreement have been fulfilled. So I think that was how we dealt with that particular situation. It is to be observed that the challenges, I'm on 6.13. It is to be observed that the challenges highlighted in the ENSCP's email related to the conclusion of the Steinhoff funding agreement instruments, and therefore by extension to the security arrangement relating to L102's guarantee and share pledge. I immediately shared this ENS email with my colleagues who were directly involved in the transaction, namely Mr. Vose Rasoroka, who is the fund principal private equity, Mr. Horatius Maluleka, who is also fund principal private equity, and Mr. Mervyn Miller, who was the then executive head of private equity at the time. Mervyn inquired whether instead of waiving the relevant CPs as proposed in terms of the ENSCP's email, PIC could make the relevant CPs a condition subsequent, i.e. deferring the date of their fulfillment. In response thereto, I indicated that PIC would not necessarily be compromised if such CPs could be fulfilled prior to the release of the security in favor of Citi, as it was only a timing issue. The email, I think I've read that email. On the same day, CDH held discussions with ENS regarding the request to waive the relevant CPs as per the ENS email. As per the advice that I provided to the PIC team, it was agreed that the fulfillment of the outstanding CPs will be deferred to a date prior to the listing of the Star shares, and that PIC would not release the security in favor of Citi until all the outstanding CPs are fulfilled. On 26 August 2017, CDH addressed an email to ENS notifying them of PIC's instructions not to release a letter to Standard Bank to release the PIC security under Project Sierra in favor of Citi until all the remaining CPs under the release agreement had been fulfilled. That correspondence is attached as Annexure L7. However, in light of the fact that failure to implement the release agreement and the loan addendum were going to affect Citi's ability to make arrangements to put the collar in place, which needed to be done a few weeks before the listing, and would be unable to do so without its security being in place, i.e. the release of PIC's 25 primary ranking security in favor of Citi, it was then agreed that CPs relating to the L102 funding and security arrangements will be fulfilled as a post-closing item, i.e. a condition subsequent. Specifically, Citi was unwilling to commit and release funding under the Citi loan to L101 to acquire the Star shares until the PIC releases its security, and therefore that the listing could not have taken place had the PIC not released the security. I think. At the time of preparing the statement, I was unable to adequately consult with CDH team to obtain all relevant correspondence in this regard. Should the Commission so require, I can establish with CDH whether they have the relevant correspondence. Commissioner, if I can also bring your attention to one of the annexures. I can't recall the email, Commissioner, but if I do, I will come back to it. Oh, am I?
I'm sure it's a matter of when you do,
Yes, Commissioner.
rather than if you do.
Yes, Commissioner.
6.19.
In attending to the process of ensuring the fulfillment of the outstanding CPs on 29 August 2017, CDH circulated the draft guarantee agreement and the 102 Star shares pledged to ENS for comments. The documents are attached as Annexure L8. During the negotiation of these agreements, a dispute arose between the parties relating to the scope of the guarantee agreement, and in particular whether it should be a limited guarantee, i.e. limited to the amounts recoverable from the realization of the 102 Star shares, or an unlimited guarantee. I attach here 2 copies of the correspondence between CDH and ENS from 29 August 2017 to 8 November 2017 regarding discussions on the dispute, including alternative proposals that L102 submitted to the PIC around 7 November 2017 in relation thereto, marked as Annexure L9. As a result of this dispute between the parties, the guarantee agreement and the 102 Star pledge were not concluded at the time of listing of the Star shares, around 15 September 2017. In light of the continuing and unresolved impasse and following receipt of the PIC of a proposal from L102 on 7 November 2017 regarding the restructuring of the security package as set out in the release agreement, on 8 November 2017, I requested a meeting between the parties, including the respective legal representatives, and warned that if the dispute is not resolved, we will need to approach the IC to provide an update on the reasons why Blue Bug transaction had not completed over 6 months after approval. The correspondence is attached as Annexure L10. Despite numerous attempts on the part of the PIC team to procure a meeting with the counterparties, there was no cooperation from them. I believe this was so because the transaction relating to the L101 Star shares had already been consummated. On 8 December 2017, I prepared a memorandum addressed to the PIC team, primarily working on the Blue Bug project, inter alia, highlighting the status of Project Blue Bug, whether L101 is in breach of the PIC loan agreement, the possible legal risk and the legal remedies available to the PIC. I attach here to a copy of the memorandum as L11. Commissioner, if I may, just to reiterate and emphasize the point, this is the advice that I provided the transaction team, and the correspondence is Annexure L11. If I may just go through a few of these paragraphs, just to emphasize the point.
Okay, then that seems to be an email from yourself to Mr. Mervyn Miller, Horatius Maluleke, Vusi Rasoroka, NCC Ernest Nesani, with the subject title Project Blue Bug Note.
Yes. If I can bring the Commission's attention to paragraph 3.3 to 3.6 and paragraph 4 of the correspondence, I will read it. It goes as follows. If one has regard to the various approval documents and correspondence between the parties leading up to the implementation of Project Blue Bug, there is undoubtedly an express intention that PIC's willingness to relinquish its primary security in respect of the Steinhoff shares was predicated on the provision of Lancaster security, and that this has always been within the contemplation of the PIC and Lancaster, and that this security is intended to be conferred to the PIC. Due to the timing imperatives of implementation of Project Blue Bug and City's requirements to arrange the hedging under the collar in anticipation of the listing of Star, the security documents relating to Lancaster 102 Star shares were not concluded on closing of Project Blue Bug, with the understanding that they will be concluded soon thereafter, but in any event prior to the listing of Star. Despite numerous attempts and requests to do so, Lancaster 101 and Lancaster Group have failed to procure the execution and delivery of Star security as it relates to the security in respect of Lancaster 102 Star shares from Lancaster 102, a wholly owned subsidiary of Lancaster 101, in brackets, guarantee and pledge over the Star shares. Clause 18.2, in brackets, other obligations, of this PIC loan agreement provides that failure by Lancaster 101 and Lancaster Group to comply with any provision of the finance documents constitutes an event of default, provided that no default will occur if the failure to comply is capable of being remedied within 10 business days of the PIC giving notice to Lancaster, and Lancaster becoming aware of the failure to comply. In our view, Lancaster 101 is in breach of this undertaking in that PIC has on numerous occasions notified Lancaster 101 of its failure to comply with ensuring that the Lancaster security in the form of 102 Star shares is conferred to the PIC. The dispute giving rise to failure to comply with this obligation and Lancaster's recalcitrant approach relates to Lancaster's contention that the guarantee referred to in paragraph 3.1 was never intended to be an unlimited guarantee, but rather PIC's recourse under the guarantee should be limited to 102 star shares. Clause 18.8, acceleration of the PIC loan agreement entitles the PIC on and at any time after the occurrence of a event of default by notice to Lancaster 101 to declare that all or part of the loans, together with accrued interest and all other amounts outstanding, be immediately due and payable. Typically, this clause would also provide that the lender would be entitled to exercise all its rights, remedies, powers, and discretions under the security document, which is not provided in this clause. However, this is not a fatal flaw, as PIC's enforcement rights are in any event embodied in the relevant transaction security documents. Clause 4. Notwithstanding that Lancaster 101 and Lancaster Group may be in breach of their obligations under the PIC loan agreement, in calling a default, the PIC must be mindful of the following issues which may be consequential to the decision taken. 1. Pursuant to Project Bluebuck and the concomitant re-ranking of the security package under Project Sierra, PIC's recourse to the Steinhoff shares and the option proceeds rank behind city loan. PIC is currently under-collateralized in respect of the STAR security. And 3, the options under the collar are European style, which means that the collar calls and puts can only be exercised at specific expiration dates. Ultimately, the decision of how to proceed is a commercial one, which the PIC will need to make. The purpose of this note is to highlight certain aspects and material legal issues which we consider material in the context of the decision on how to proceed, and those aspects which are likely to have a material bearing on PIC's final decision.
What was the response?
Commissioner, through you, I did not receive a response to this particular correspondence. I must put it on record that soon thereafter I went on maternity leave, but I did inquire with the team, what happened pursuant to me highlighting these risks and these potential breaches. And the team did indicate that there were commercial discussions between PIC, Steinhoff, and Lancaster, which I was not privy to. I then requested that perhaps we need to do a proper write-up to the Commission, just detailing what happened in those deliberations. But I'm not privy to any of those discussions.
Has this, Mohabe, has this issue and the discussions that took place consequent to this appeared in any other document that we've received? Because I'm not familiar with it.
I do not recall that there was anything that was placed before the Commission speaking to that, Commissioner.
Commissioner, if I may, I did the inquiry yesterday and I was told telephonically that there were discussions that happened between the three entities, and I did advise the team that perhaps it would be worthwhile to provide the Commission with this information.
I think it's necessary to provide us with the information. Yeah, it's imperative to do that. But if you are able to, what exactly is the exposure of the PIC now and to whom? Given all of these issues, there's the Citibank, there's the whole convoluted structures that have been created around this deal. Exactly what is the PIC's exposure to Steinhoff, as we said earlier, Steinhoff itself, but particularly Lancaster in any form? What is that exposure? Do we know offhand?
Commissioner, we can certainly provide the Commission with that information, but given the legal structure or the transaction structure that was implemented in relation to Project Bluebuck, the PIC's exposure is on L101, and our exposure insofar as L102 is concerned is in relation to the guarantee and the pledge that was signed between the two entities. But as I've indicated earlier, because of Steinhoff's non-participation in L102, we effectively have security and we have rights over the shares of L102, which are legally enforceable, but unfortunately there's no value underpinning any of those shares because of the non-participation by Steinhoff. But I think from our end, we will definitely do a write-up to the Commission, just explaining the exposure and detailing what steps were taken pursuant to this email being issued from the PIC's end.
And perhaps if you could, I know you come to it a little bit later, but in terms of the structure that was put in place, can you look at the arrangements made and advise or comment on whether there was adequate protection for the PIC in all of this structure? Because again, I think in one of our previous discussions or witnesses who appeared, the roll-up now of the exposure was 11.5 billion from the 9.5 originally lent. So I think that it would be just important to look at what the structure of this meant for the protection of the PIC in relation to City and the loan and Lancaster and Steinhoff all together, to say, did the PIC take its own protection seriously enough? Did it guard against default in a particular manner? Did it actually preserve its rights in an adequate way? Because it seems to be very questionable to me.
Commissioner, through you, we will definitely take those points into consideration and prepare a write-up for the Commission. Paragraph 6.26. I pause to mention that the conclusion of the guarantee agreement and 102 star share pledge alone was not sufficient in the absence of the conclusion of the Steinhoff loan agreement and the advancements of the 6.2 billion and the actual subscription by L102 for the star shares. On 11 February 2018, Mr. Jahendra Naidu, on behalf of L102 Lancaster, apparently addressed an email to Mervyn dealing with steps that Lancaster was supposedly taking to address the non-compliance with the outstanding conditions. As I was not copied on the said mail, Mr. Naidu and from Mr. Naidu, I am not privy to the contents of such email. As a follow-up to Mr. Naidu's email, ENS circulated a letter from Steinhoff International dated 27 July 2017, a copy of which is attached here too as Annexure L13. I was requested by the PIC internal team to advise on the legal effect of the Steinhoff letter. I provided my views thereon on 14 February 2018, to the effect that, inter alia, the letter had been overtaken by events and that it has no legal consequence and not legally binding. It is to be noted that the Steinhoff letter was provided to Lancaster at the time when Lancaster approached the PIC in respect of Project Bluebug. On 15 February 2018, and following my advice on the status of the Steinhoff International letter, my colleague Mervyn, who was the executive head of private equity at the time the transaction was concluded, indicated that he had asked Lancaster to conclude a binding agreement with Steinhoff International in relation to the contents of the letter. A copy of the email correspondence between myself and the other PIC team members is attached as Annexure L11.
You mean L14?
L14, my apologies.
And sorry, can I just go back a second, and can we try to obtain that 11th of what the document referred to in 627 from Mr. Naidu about to Mr. Muller about the steps that Lancaster was supposed to be taking? Can we obtain a copy of that, Advocate?
Commissioner, through you, I think it was an email correspondence, email referring to a correspondence. I'm not in possession of that correspondence.
That's why I'm addressing that to the advocate.
Okay, noted, Commissioner.
Thanks.
Paragraph 6.31. I understand that discussions between business and Lancaster were held afterwards in order to resolve the breach of the release agreement and/or the loan agreement. The legal department was not part of such discussions, and therefore I'm unable to advise the commission on what was agreed. But if I may read into the record that we provide the commission with an undertaking that we will source that document.
And indicate exactly when you talk about business, who and what in business. I'm assuming you're referring to elements within the PIC who would have dealt with that, but can we just get exactly who?
Yes, Commissioner. By business, I'm referring to the transaction team, which would have comprised of Mr. Mervyn Miller, Mr. Vusira Seroke, and Mr. Horatius Malulek. Perhaps if I can now deal with paragraph 7, Commissioner, which relates to lessons learned. 7.1, we reiterate that the role of legal in any transaction is limited to assessing, identifying, and mitigating legal risks. Commercial decisions do not fall within our purview or the purview of legal. Ours is to ensure that the legal documentation reflect the commercial agreement between the parties. As it relates to the swapping of securities, ours was to ensure that from a legal perspective, the existing security was released and replacement security was properly in place. The decision to relinquish security in favor of Citibank and replacing it with new shares.
I want to stay with a question about whether you, in a technical manner, required a different.
I think, Commissioner, you're correct in the sense that once we picked up this behavior from Lancaster, we, as legal, we thought it would be prudent to highlight the fact that they, pursuant to city's funding flowing, there is no will to finalize this transaction to ensure that the PIC security is safeguarded, which is why we sent the email to say perhaps it would be opportune for us to call on our security and basically unwind this entire structure so that we can realize whatever value we can possibly realize, given the fact that, Lancaster, which, and I must put it on record, Commissioner, that we haven't had any interactions with Steinhoff directly. So they were essentially the go-to or the middlemen between ourselves and Steinhoff. So it became very...
Who was the middleman?
Lancaster. Yes, I can speak from personal experience. I haven't had any interactions with Steinhoff. That's why it became critical for us to assess whether or not, given the risks of, the share depreciating in value and the fact that our security was not forthcoming, we needed to take a view as the PIC whether we revert to, the original status of the PIC and reverse this entire transaction so that we can safeguard our position. But unfortunately, the steps that needed to be taken pursuant to that email didn't follow through.
All right, paragraph 7.2.
With the benefit of hindsight, one is now able to reflect on processes leading up to the listing of Star and implementation of Blueback critically. Undoubtedly, one could have never foreseen the eventual decline of Steinhoff shares and consequential losses to, amongst other things, shareholdings and funders. With this in mind, the question as to whether the PIC could have done anything better should nevertheless be addressed. In order to make good Steinhoff's commitment to provide additional funding to L102, we ensured that the funding and security arrangements relating to the L101 and 102 acquisitions of Star shares were included as CPs in the transaction agreements. In addition, when on the date of fulfillment of the CPs, it became clear that such commitment was not provided to L102, we insisted on an arrangement which was aimed at ensuring that the PIC would not release the securities until this commitment is provided. However, due to time pressures relating to the listing of the Star shares, the PIC made a concession to release the securities to enable the injection of city funding into L101, and therefore the listing of Star shares. With the benefit of hindsight, perhaps the PIC should have insisted on a commitment relating to the funding of L102 prior to the release of the security, irrespective of the fact that it would have had a prejudicial effect on City's funding and the listing of Star and possibly collapsed the transaction.
Mr. Commissioner, that concludes Ms. Dlamini's evidence.
Yes, your last line of paragraph 7.3 is quite something that worries us a lot a bit, in the sense that even with the IO listing, there was those pressures about, this listing and all that, and then it ends up compromising the PIC. I just want to understand, why can't the PIC collapse transactions and say, look, this is not in our interest, and we're just going to stick to what we want to do?
Commissioner, it's a very loaded question, and I think it's a very difficult question because, unfortunately, Commissioner, we are not involved in the commercial discussions between the likes of Jahindra and the CEO at the time. And unfortunately, we find ourselves in a position where, we try by all means, as has been demonstrated in, the annexures and the submission, to stick to the principles of, the governance processes or structures. And I think at all times we indicated to our counterparties that to the extent that, you need us to move, we need to move through a governance process. Unfortunately, Commissioner, we find ourselves where, and I think this is also evidenced in Ms. Carmichael's email, where we are being instructed that, look, at the end of the day, commercial discussions need to be had and commercial decisions need to be made. And I think we are then operating on the premise of advising the business, but allowing the business to make commercial decisions such that we are not stifling the business in making those decisions. It's a bit of a catch-22 for us as legal, because while we may not necessarily agree with the decisions that are being made, which has, I think, been adequately evidenced in the submission that I've made, at the end of the day, commercial decisions were made to, well, whether it's taking into account legal advice or not, I think that remains to be seen.
If I understand you correctly, on your side, you did your bit as legal in the PIC.
Agreed, Commissioner, and I think we've tried our level best to demonstrate that we needed to keep within the confines of the resolution that was provided by IC, and to obviously deal with implementation issues as best as we can, but also in keeping with the prescripts of the IC resolution.
But I mean, really, it's this stuff about the PIC not wanting to collapse a transaction because of a listing, I think is something which needs to be looked into, because it has cropped up a number of times, I think.
Agreed, Commissioner.
Yeah, okay. Further question, one or two more questions. Just in terms of complexity of transactions within SIPs, is this the one, is it the most complex, or there are more which are more complex?
Commissioner, I think with the benefit of having done a few SIPs portfolio or SIPs transactions, Pareto would have been one of them, which was also, I think each SIPs transaction is complicated in its respective rights. I mean, if you look at Pareto, it was the first time we were implementing a contingent repurchase obligation type structure. So I do believe that they are complicated in their own respective rights. It's just a matter of understanding what the end goal is and making sure that all the necessary steps to get there are effectively implemented.
Next one, these are broad questions now. These are broad questions.
No problem.
Yeah. Transactions take long at the PIC and other places, you know, in general. And if you look at, say, vacancies in the legal department, I mean, how long does a typical transaction take, like, you know, in terms of legals, you know, as they say, this is a transaction, it must go to legal, and you know it's another 2-3 months or so. Do you think that the vacancies actually, they worsen this kind of a problem?
Commissioner, it actually brings me to the point that I touched on in my statement, or in one of the annexures, where I indicated to the team that, you know, if we don't close this transaction within a period of 6 months, we need to go back to committee and appraise the committee of any material eventualities that have happened on the transaction that are leading to the transaction not closing. So that now talks to the process of finalization of transaction agreements within the PIC. There is I'm not sure if it's a process or a policy, but there is a process within the PIC that indicates that if a transaction doesn't close 6 months post approval, then you know, you need to bring to the committee the reasons why this transaction is not closing. It could typically really be, you know, the negotiations are very protracted and they're just taking a long time, or it could be there is something fundamental that is stopping this transaction from closing. You therefore have to bring it to the attention of the committee. So under those circumstances, we would make a formal submission to either request an extension, but also highlighting what, you know, the negotiation processes and what have been the hiccups or the potential impasses on that particular transaction. So we give ourselves a 6-month leeway to finalize transactions, and post that we will have to take it to committee. One of the things that the committee needs to consider is whether they still have appetite given the material eventualities that may have happened on the transaction, whether the PIC still has appetite to proceed with the transaction.
But given, there's something like pre-approval, I mean, it's another, 3 months, 4 months or so, and then post-approval is another 3 months or so. Is there a way in which transactions can be fast-tracked? I mean, if, say, you fill vacancies and all that, is that possible? Is that doable?
So, Commissioner, through you, I think we need to discern between the processes of getting the transaction approved and a process of implementing the legal agreements. So, the process of implementing the legal agreements is it's a standard practice that 6 months is attributed to that process, given the complexity of the documents and the protracted negotiations that may eventually happen. But in terms of the approval processes, I think people before me would have come to just explain the governance process, but given the fact that transactions need to go through various governance committees, and if issues are raised, we have to go back. We need to do some more work, to get the transaction to a point where it's palatable to the PIC and PIC is comfortable with the transaction that's packaged before them. So until a stage or until a time that happens, unfortunately the transaction cannot be approved simply because it needs to be fast-tracked. We need to ensure that, all the risks that have been identified are adequately mitigated in our proposals as assurance providers. We also need to make sure that the financial terms of that particular transaction are in line with the PIC's mandate with its clients. And I think those are the considerations that really take quite a bit of time to get the transaction to a mature stage before approval.
Not much can be done about this. Is that what you're saying?
Commissioner, I do believe that if you capacitate the PIC with the necessary resources, it will obviously have an impact on the deliverables. It will have an impact on efficiency. I think you will resolve those two issues by effectively capacitating the relevant units, because the work will obviously be done a lot faster and a lot more efficiently. So I think it takes care of the efficiency element from in that regard. But I still do believe that the processes, the governance processes will still need to remain intact and will still need to be respected, in the sense that the PIC will need to apply its mind to whatever the proposal is brought before them and make sure that it ventilates the issues robustly and ensures that it's comfortable with the transaction that comes out on the other end.
Next one. Just in terms of the legal department and how things, the climate there, how things are. We had witnesses here saying you have lost the head, I think Mr. Nesane, and there are issues up and down there. How is the climate there currently in the legal department? You are the acting head now.
I got a sense that this one was coming. Commissioner, through you, and I think this is a very serious matter. Commissioner, I can only speak for the role that I've currently played in the 3 months that I've been acting. Perhaps if I can take the Commissioner back. I was presented with an opportunity to head up legal in January this year. And I wasn't given any formal reasons, but I think, it's really pursuant to my interactions with the relevant members of the management team and the board in the transactions that I've been managing. I think the rationale was that, look, we are looking for somebody who strategically can manage the legal department, provide strategic leadership, and steer this ship in the right direction, and to adequately and efficiently deal with the issues that are are currently at play at the moment. I took up this opportunity. This is pursuant to the board resolving to bring me on board. I've assisted the PIC, and I think I need to put it on record that one of the functions that I espouse to is to servicing the PIC. I don't service any individual on any board. I don't service management. I service the PIC in all the legal issues that the PIC effectively needs to deal with. One of the issues that, and I do agree, Commissioner, the legal environment was quite a segregated environment. People were working in their own respective spaces. They were working in silos. One of the things that I've undertaken to do as the acting head of legal was to make sure that the issues that are emanating on the ground are effectively dealt with. I've had one-on-one sessions with each individual within the PIC legal space, and I try to engage them to find out what are the issues that we need to deal with to make sure that we're optimal and we're efficient and we're working to service the company. We've had those discussions. I can safely say, Commissioner, through you, that one of the key issues that people wanted to do was to have access to work. This is primarily one of the things that I've since done. And I can report to the Commission that the environment is slowly but surely changing. People are becoming more and more confident in their roles. People are becoming more and more comfortable in what they're doing. And I think ultimately at the end of the day, people are servicing the business, which is what we need to ensure. We need to ensure that we are functional and we are functioning optimally and not substandard. So I think that's all I can say in relation to the culture of legal at the moment. Obviously, this is a process. It will take time, but I think it's quite imperative that we deal with the issues on the ground to make sure that the legal team or the legal unit is functioning optimally.
The final question is, I'm sure you might have answered it here, but if you can add more, it's fine. I note that there was no Advocate Mohapi in terms of the person, the witnesses that we normally see qualifications and the jobs they've done and all that, but I know that this was not here. It was just on the PIC only.
Commissioner, in respect of that, I'll let the witness speak to that, but she decided it was a conscious decision on her part not to put those qualifications, but I think she can give evidence to that effect.
It's up to her. It's up to her. She must decide. You want to do it. If you don't want to do it, it's still fine. You know.
Commissioner, it was actually an oversight on my part. I actually realized when I was watching one of the witness testimonies yesterday that the resume in relation to the education and the background is read out. But I can provide the Commission with this information. I have it on my laptop. If the Commission would
Tell us for a minute or so. I mean, it's
okay.
You know yourself. You know.
I know.
Yeah.
Yes, Commissioner. As I've indicated, I'm an admitted attorney of the High Court. I just need to get a list of all my certificates. There are quite a few.
Just briefly,
Okay.
the key ones.
Commissioner, I do possess an LLB. I possess an LLB with the University of Johannesburg. I possess a LLM with a University of South Africa. I'm currently doing my LLD with the University of South Africa. I've done quite a few certificates on company law. I've done quite a few certificates in the financial space, so in terms of the financial markets and the like. Unfortunately, I don't have the whole list with me. Previously, I was at Cliff Decker Hofmeyer. I did my articles there, and I was an associate there. I then left Cliff Decker Hofmeyer and I joined the PIC. I started off in the corporate services, servicing the corporate part of the PIC, but I was also doing listed transactions while I was there. I subsequently moved to unlisted in 2015, where I was primarily servicing the private equity team. I was servicing the developmental, it's called impact investment now, but I was still doing some listed transactions. So I've got an all-round view on the PIC because I've essentially serviced each and every single department, including the IT space. I think the only department I really haven't serviced at the PIC has been the Human Resources Department, which I'm currently working with now. But that's effectively my background and my experience, Commissioner.
Doctorate, what area are you doing there? You know, I'm a lecturer, so I'm a part-time lecturer, so I'm quite interested normally in this.
So, Commissioner, I did my LLM on consumer credit law, focusing on, the development of consumer law in relation to Companies Act, what are the loopholes, what are consumers' rights and the like. I've consciously decided that I need to do a further work on that space because there's critical, developments happening in the space. So I've opted to proceed with that topic, consumer credit law, for purposes of my dissertation on my LLD.
Thank you very much. I'm enlightened.
It's a pleasure.
So, having presided in some cases concerning the Credit Act, we'll find some criticism in your dissertation relating to our judgments, and I think I've written one of them. I'm not sure.
You certainly will, Commissioner.
Yes, thank you. So that's it for the day.
That's the business of the day, Mr. Commissioner.
Right. Ms. Dlamini, thank you very much, and thank you so much for your time. You know, I need to mention that I've been impressed by actually all, being a lawyer myself, I'm impressed by all of the people who come from your department who testified before us. Quite impressed.
I'm glad to hear that, Commissioner.
In fact, I asked myself whether you in particular would maybe go back to practice and one day become a judge.
Once my kids are a lot older, Commissioner.
Yes, all right. Thank you once again. Thanks
It's
for
a
your
pleasure.
time and thanks for the work that you've done in putting together your affidavit. There's certain information that's been requested of you. Don't be surprised thereafter if you are called in again to come and clarify certain issues relating thereto. Okay. Otherwise, thank you very much, and you may be excused.
Thank you.
Mr. Mohapi, we're going to adjourn now, and it seems that we'll adjourn until the 13th of May. 10 o'clock again at this venue, just to explain that we understand that, in fact, it's been confirmed this morning that on Monday we wouldn't be able to sit because of some protest or action that's going to take place in Pretoria.
That is correct, Mr. Commissioner.
Yes.
On the 29th, isn't it? Yeah?
29th.
Monday
that's
the
correct.
29th.
Monday
There's
the
a shutdown.
Yes, Monday is
There's a
the
shutdown.
29th, Yes.
Yes.
Okay.
And then we would have just one day following that, and the next day is a public holiday again, the 1st of May. Usually we finish on Wednesdays, so we won't be able to come back. And the next week again, we understand that there's going to be council meetings and so on at this venue.
And it's the election.
And then on Wednesday will be the elections, which means that we would have just one day in between, and that would be the...
That is correct, Mr. Commissioner. So we've got these pockets of days which wouldn't serve
so
any
for the
purpose.
next 2 weeks, it won't be practical for us to come and sit. Yes?
And it seems that on the week starting the 6th, Monday the 6th, people want to go home to vote, the legal team and all that, so we couldn't even
That's
look
right.
at that week too. Yeah?
That is
Yeah.
correct, Mr. Commissioner.
I've just been given a note to say that we actually come back on the 14th. I'm not sure about that. Can
Yes.
you just-
Is that the 14th?
14th,
That's how I have it, Mr. Commissioner.
14th of May.
We've been provided by the Secretariat with schedules saying that in our planning we should take all of what Mr. Commissioner is pointing out, and that the next sitting will be on the 14th.
Yes. So let's correct that. It's not the 13th, but rather the 14th of May. Yes. Okay.
Suffice to say, the work continues.
No, certainly. The work continues. Your work as a legal team
Most certainly, Mr.
and our
Commissioner.
work as sitting here, it will continue. Yes, we'll then adjourn until the 14th of May at 10.